the Maryland law, which takes DNA from people after they are arrested and after they are charged with a crime, the taking of the DNA and the analysis of it before the conviction is permissible. The majority reasoned that it was permissible because the use of the DNA to determine the identity of the individual for the purpose of checking whether they might have committed another crime having nothing to do with the arrest was reasonably seen as part of the booking process, part of the arrest process, part of the criminal justice process. It would produce useful information in some cases for deciding who should be out on bail and who should be detained. The real purpose of getting this evidence is not to make bail determinations. That was not what it was used for in this case. That is not what the statute said it is set up to do. It is to see if people are guilty or might be guilty of other crimes to which there was no connection previously. And the DNA is obtained by inserting a swab into the mouth of the arrested person. That is an affront to the individual that cannot be allowed without some suspicion that the individual has committed a crime for which that DNA evidence would be useful. The court seemed to be asking on a case-by-case basis, which is more important, the state's interests in getting a hold of private material or the individual's interests in keeping that from prying eyes. If I had the power to decide this, I would come out the same way that the majority of the court did, though I would write a somewhat different kind of opinion. What I would prefer would be an approach that says there is an exception to taking certain information about people, even if they don't want to give it to you. But it's got to be very limited information about their identity. So you can take fingerprints. It's not particularly obtrusive. You're not probing the mind of the person. You're not invading the body like taking a bullet out of a person without consent and without a warrant. Those are different. But if you're just collecting biometric information, scanning the iris of the eye to create a record of someone, getting a fingerprint and using the fingerprint for various purposes, in that case, I'd say there ought to be just an exception that where that is the only thing that is done, the Fourth Amendment does not require what it would for a full-blown search. Federal system requires an indictment. California doesn't. Maryland did. Well, is that going to be a difference? So what about familial searching? There, the people who are affected aren't even the ones in the database. Now, the Supreme Court's majority opinion noted that Maryland doesn't allow familial searching. So what about California that does? So what if it turned out, contrary to the expectation of some scientists, but consistent with the fears of some others, that these profiles that are on record could themselves be used to infer something about disease status? It would introduce a privacy concern that is currently not on the court's horizon.